Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode.
And friends, welcome back to Callaway County. We are here with attorney Jeff Roberts. Jeff, good to see you.
How are you, Jim?
Buddy, I'm doing well. Thanks for taking the time out to do another podcast with us.
Yes.
So today we're going to talk about lump sum settlements, pros and cons, and some issues that come up. But we're also going to talk about something very important called lifetime medical that has to do with your workers' compensation settlement. So, Jeff, let's talk a little bit about the idea of a lump sum. Do you want to talk let's define what it is first and when it might come into play and when it wouldn't?
Yes. In regard to a workers' compensation claim, you can frequently settle the case on a lump sum basis. A lot of people think when they come in to initially talk to me, they think, well, whenever we do settle the case, it's going to be a lump sum. And that's not necessarily the case. If you settle it, you can get a lump sum with a settlement. If the case goes to a judge's decision, then workers' comp benefits in Kentucky are paid out weekly over a period of time, depending on the extent of the disability.
Right.
From that, so it could be 425 weeks, it can be 520 weeks, it could be to age 70, depending on the extent of the disability that the person has. And if you go to a judge's decision, if you're not able to settle the case, all a judge can award is weekly payments. A judge cannot award a lump sum. Now, a part of that award would be back pay for weeks that have already passed, and that would be paid in a lump sum because we're catching it up.
Yeah.
But then it would be paid out weekly into the future. With a settlement, as long as both sides agree to a lump sum, then frequently they do, then you can get all of those weeks in a lump sum amount. You have to give a little bit of a discount to account for the present worth of that of those weekly payments, but frequently you can get a lump sum in that setting. There's different things that you need to look at on whether you want to do a lump sum or do not want to do a lump sum in a case. If I've got somebody that I've represented, I know that they, if they're back at work and earning good wages again, and what they're earning now is going to take care of their bills into the future, and we don't have to worry about that, so they only have a partial disability. Those are cases that I strive to try to get a lump sum in those situations because you can actually put somebody in a better situation. I think the present work table is like 3.75 now, so it's like a discount of 3.75 you take.
What does that mean? What does 3.75 mean in
percent?
Okay.
Yeah, percent of the thing. So it's, like if you go borrow money, you pay interest on that. Yeah. It's kind of like reverse interest. You're taking a 3.75% reduction to get the lump sum.
Well, it's kind of like the lottery. It's kind of like the lottery. If you take the cash option, it'll be a little bit less.
Yeah, if you take the cash option, you're getting less money. Yeah. Well, a lot of people have a car payment or a house payment or credit card debt, and they're paying much more than 3.75 interest rates in that situation. So usually it's better off financially, even though they have to take a little bit of a hit when they get that lump sum. If they use that to pay off some debt that has a higher interest rate, then they've made money from that standpoint. And so those are very good situations to do a lump sum if you can reach a fair lump sum value. Right. That's a big key factor too.
Well, there's two quick things I take up from that. You really need to be speaking to your workers' compensation attorney.
Correct.
There's a lot to consider, and what may look like a good deal up front, may not be, for your particular situation. And that leads me to the second point. Everybody's situation is unique.
Correct.
And it, what may have been good for your buddy, who got injured last month or, last year on the line, it may not be the same factors for you.
Absolutely. And that is true. So, and so every case is based on its own set of facts in that regard, and your situation will be different than your friend's situation. Financially, you may be in a different position than your friend was, hopefully in a better position from that, but you may be in a worse position, and that makes a difference as well. If I've got somebody who is they were living paycheck to paycheck beforehand, and now they're way behind on their bills, and they're in fear of losing their house or losing their vehicle. Well, getting a lump sum to allow them to catch up, it can be a big factor there and take a lot of stress off of my clients in that situation. So when I'm talking to a client, workers' comp client, about settlement and whether we should do a lump sum versus weekly payments, that's something I'll look into. I will frequently say, well, tell me about how much debt are you in? How much savings do you have now? What are your bills compared to what your income is now? And things of that nature, so that we can discuss all of it together and reach a obviously the client is the final decision maker. I can advise the client on what I think is the best for them. They are the final decision maker. It's their case. It's not my case from there. So if they say they want a lump sum settle and we have that offer on the table, and it's a case that I think it may not be in their best interest, I'm going to advise them that I don't think it's in their best interest, but if that's what they want me to do, that's what we will eventually do.
Yeah, so. That makes sense. A while ago, this has been a few months back, episode 127, actually, we talked about structured settlements in workers' comp.
Right.
And so if you have a lump sum, that's another avenue for kind of protecting that money and actually stretching it a little bit further to make sure it's there. Do you want to talk a little bit about this? Friends, Jeff's not going to tell you this, but this was part of the episode. This may have been, this case that we actually referenced in episode 127, may have been the largest workers' compensation settlement in Kentucky history, and that's something you did for one of your clients who elected to do this structured settlement option.
Right. We did the structured settlement in that case, and at least from the people I've talked to, no one knows of one that was a larger workers' comp settlement than that case was. So in that case, the lump sum was by far the best for that client in that situation there, and we were able to get a lump sum that was with the annuity, the structured settlement. We got a good lump sum amount plus the structured settlement with the annuities. That's going to take care of the income aspect for the rest of that client's life in that situation. So, every case you got to look at the facts of that situation from that standpoint. So that's there's a lot of things that you have to take into account on whether you want a lump sum or weekly payments, what's going to be best for the clients. If I've got a client who is severely limited in the amount of income that they can earn, but they haven't been able to get on Social Security disability, then we may want those weekly payouts to make sure they've got that steady stream of income coming in the future to pay their bills. Yeah. So,
well, that makes a lot of sense. And Jeff, you're coming at this from a perspective of you've practiced workers' comp for over 33 years now here in Kentucky.
Correct.
So you've seen a lot of situations, you've seen a lot of cases, you've seen a lot of different variations that come with these cases. And so I think when you're adding your advice, for your client's benefit, they're getting that knowledge. And that's a definite something to listen to, right?
Yeah. It is. And the clients sometimes have different views. I've had some where I had a good lump sum settlement proposal on the table, and the client said, "No, I prefer the weekly payments than I do the lump sum." Doesn't happen often, but it does happen at times in that regard. And so it's you've got to listen to the client. Give the client all the information that they need to make an intelligent decision, but then trust the client to make the decision as to what's best for them.
Yeah, so. And that's you're there to advise,
exactly,
and handle the case of, through the system. So what we're going to end up doing a little bit later on in this episode is talking about lifetime medical, and that's something that's gone through a change here a few years back. But before we get to that, we were talking about really the payouts and the, either a lump sum payout or what. And if the judge's decision, if it comes down to that, he can't do a lump sum. We talked about that. But there are also a lot of other benefits within the workers' compensation system. Back in episode 121, you kind of went through all of those. So, but there are also medical benefits, and that's
Correct.
going to be our segue, obviously. But you want to talk a little bit about the other benefits beyond just the monthly payments, the weekly payments?
Besides the income benefits, you got two types of income benefits, what's called temporary total disability, which is what you receive when you're off work under doctor's orders, receiving medical treatment until you reach maximum medical improvement. And then it converts to permanent disability benefits, which is what we're talking about on the lump sum amount. The other benefits are vocational rehabilitation. If you're not able to go back to doing work you've done in the past, then we can look at getting you retrained into another field so that you can get back into the work market and earn a good living wage, or the medical benefits, as you talk about. And we have the medical benefits under Kentucky law. And up until 2018, medical benefits for work-related injury, for every work-related injury, was lifetime. Medical benefits. That changed in 2018 when they passed a law then. They passed a law in 2018 that you have lifetime medical for certain situations, but most cases are not lifetime. It's going to be 15 years with the ability to ask for lifetime at the end of 15 years. So the ones that get lifetime medical benefits now, if you're found to be permanently, totally disabled from the work injury, then you get lifetime medical benefits. If you have an amputation or partial amputation of arm, hand, leg, foot, then you get lifetime medical benefits. Obviously, if you need prosthetics, those will wear out over time, so you need to get lifetime medical in that situation. If you have hearing loss or vision loss, you get lifetime medical in that. And one other, or not just vision loss, loss of an eye, I should say, hearing loss or loss of an eye, and then loss of a tooth.
Oh, really?
Yeah. Loss of tooth. So if you need dentures or anything or implants because of that, that's covered lifetime too.
Okay, so if you had a facial injury,
correct,
and you had that I don't think we've ever talked about that before.
No, it's not something I've actually seen where I've had a client that's needed lifetime medical. I've had clients in the past
for a denture.
Yeah, exactly. I've had clients in the past who've had those type of injuries, but I don't think I've had one since 2018, so I hadn't even faced it since then.
Interesting.
From that perspective. So now, if you're not in one of those categories, then medical will continue for 15 years. And then near the end of the 15 years, you will get a notice from the Department of Workers' Claims that says your 15-year period is about to expire. If you think you need medical ongoing, you can ask an administrative law judge and fill out paperwork to get a judge to decide that. The insurance company would be able to respond and say, we don't think he needs future medical past the 15 years, and this is why we don't think this claimant needs it past 15 years. And then the judge will make that determination. Now, exactly what that process is going to look like, we don't know because we haven't hit the first 15 year for someone because the law come in 2018.
Yeah.
So it's going to be 2033, I guess, before the first person ever hits that 15 years. So exactly what that's going to look like, I can't tell you at this point from there. But you still have the potential for lifetime medical. Yeah. So, and I suspect that people who have joint replacements that wear out over time and you have to have that, those type of individuals will probably get the 15, get it continued if you're still having ongoing medical treatment for it. So some back injuries, for instance, people are receiving chronic pain treatment, and those I would assume are going to get it. But if you haven't had any treatment in the last 10 years for your condition, you very well may not get the lifetime medical.
Well, and that brings up a good point. If part of your recovery plan, your treatment plan, the plan that the doc has laid out for you involves ongoing therapy and things like that, it's one of the reasons you need to kind of continue with that regimen, right?
Correct. And one of the things I tell clients is, especially if they've had any type of surgery or injury to a joint, is to see a doctor every 6 months to a year, usually about on a yearly basis, because if you're having ongoing pain from the work injury, but you're toughing it out and not going to the doctor, and then 5 years goes by and you go back to the doctor and say, this is getting, my shoulder, we're just going to use shoulder, my shoulder's really bothering me. I need to get something done about it. Doctor looks at it and says, oh, yeah, now you need to have a replacement. You got a lot of arthritis in there. You need to have a total shoulder replacement. Well, the insurance company's going to look at it and say, you went 5 years without any complaints of pain to this doctor. And so we're going to assume you did something outside of work that's caused this to get worse, and we're not going to cover it, and we're going to fight you, and you got to go through the litigation process again in front of a judge and have a judge decide it, and you're going to have a hard time in that situation. So I tell clients, if you're still having problems, see the doctor every 6 months or every year, and just tell the doctor, my shoulder's still bothering me. I can still handle it. I can still deal with it. I don't want any surgery or anything at this point, but it's bothering me. It's getting a little worse over time. And then you've got it documented. So 5 years from now, 10 years from now, the doctor says, yeah, it's time for us to do surgery on this. They can look back and say, oh, he's consistently complained that it's been getting worse over time.
Yeah.
And you're much less likely to have a fight over that medical treatment.
You've got a legitimate paper trail.
Correct.
And that probably makes your job a little bit easier.
Makes my job a lot easier in that situation, yes. And makes your chance of being successful in front of a judge a lot greater.
Yeah. Jeff, let me ask you this. If I've got an injury, workers' comp injuries, I was hurt on the job, and let's say I had to get something with my left leg, okay? Sometimes even after recovery, I may start favoring that, and maybe I'm walking a little differently, whatever. So it could later on cause an injury, or suddenly I'm feeling pain on the other side now because I've been compensating.
Right.
Would Lifetime Medical take that into account? I mean, can that be part of my claim over time, or is that just that's not work related?
No, it can be taken into account.
Really?
Absolutely, yes. What you have to have, though, is you have to have a doctor make that correlation.
Yeah.
So you can't just say, I was favoring my left leg, so I was putting a lot more weight on my right leg, and now my right hip is going out. You saying that's not going to do anything. If the doctor says with his left leg injury, he was having to bear more weight on the right leg, right hip is going out because of the effects of the work-related injury, that should be covered under workers' comp.
Even though that wasn't originally part of the injury that you sustained on the job.
Correct.
Okay.
Yeah.
Okay.
Yeah. Because it is an effect of the injury.
Okay.
From that standpoint. So frequently we'll see a person who has a low back surgery, and if they have a low back fusion at, we'll just say L5S1, which is the lowest level, a lot of times over time, because that level is fused now and does have no movement, the level above will wear out, called adjacent segment disease, and then people will have to have treatment for that, even though the L4-5 level wasn't injured in the work accident. 10 years later, it's now symptomatic and may need treatment for it, and that sometimes they'll fight you over that, but that is usually covered.
Right, because with that fusion, sometimes as you climb up that ladder on your spine, it causes the other problems. Right. Okay. Because this isn't as mobile down here, so now I'm compensating up here. Okay, that part makes sense to me.
Yeah. And kind of to connect the two, the lump sum to the medical, a lot of times when you are talking about settling a claim on a lump sum basis, the insurance company wants you to waive certain things. Frequently there's some who will say, we're not going to settle on a lump sum unless you waive future medical. And that's a huge red flag for me. I don't like to settle future medical for my clients unless I know there's a good backup for them in that regard. And some will say, okay, we'll leave medical open, but we're going to close out the right to voc rehab. So if the injury ever causes you not to be able to continue doing that type of work, you cannot go back to get voc rehab if you've settled that out, and settle the right to reopen, which in workers' comp, if you settle a case, you've got a 4-year window from that first settlement that you can go back in. If your disability increases within 4 years of that settlement, you can go back in to get more money in that situation. And if they're going to pay a lump sum, they don't want to pay you a lump sum now. And then a year down the road or 2 years down the road, you come back in and say, Now I want more money.
Yeah.
And so they want a waiver of the right to reopen and vocational rehabilitation in about every lump sum settlement that I see, proposal that I see from there. And frequently they'll try to throw in future medical. A lot of times when I say future medical is off the table, they will keep the lump sum. They just they want to close out the case, and so they're just trying to get it if they can.
They got to ask, right?
Yes.
Yeah, they got to ask. And that's part of that give and take during a negotiation. Again, you've got 33 years of experience, almost 34 years of experience now, negotiating with these. So you kind of have an idea of what is probable, what that case might be able to be worked out as in terms of resolving the case, because you've probably seen it before.
Yes. Very few cases do I have now that it's not something I've dealt with in the past. Over 33 years, I've handled pretty much every kind of injury and most kinds of occupational diseases in that 33-year period of time. So I won't say that I don't occasionally have someone come in with a condition or situation that I've not seen at some point in the past. But even if I have seen the condition in the past, this client's situation is going to be different than every other client situation. Their age, their educational level, their financial stability, all of those things come into play in dealing with it. So it's all every case is its own case from that standpoint.
Yeah. So, I mean, and this term gets used fairly frequently, but you've got to take a holistic approach to what's life like for that client at this point and going forward.
Correct.
And then, just kind of work with the variables you have.
Absolutely.
Okay. That makes sense. So, as we kind of close out the discussion of lifetime medical, how does it work? I mean, in reality, okay, so we've settled the case. I've got some money up front, but I need to keep up, as you said, at least once a year, go check back in with my physician, let them know kind of how I'm progressing, new things that are cropping up.
Right.
Are the bills for that claim or that visit, that doctor's visit, are they just sent in to the insurance company, or how does all this work?
It kind of depends to some extent, to be honest, because if you're going to your family doctor for your yearly checkup and that's who you're complaining to, and then they're checking your cholesterol level and all of this, fine for that to be billed to your health insurance in that situation, in my opinion, because that's just, okay, doctor, I just want to know my shoulder is still bothering me type situation, but you're there mainly for the yearly checkup, not the work injury. If you're going back to a specialist that's treated the work injury and that's all they treat, then that would be billed back to the workers' comp carrier there. You should get, early on in the process, you should get a card that's got all the billing information and where the bills need to be, the claim number, who they need to be sent to, and you take that just like an insurance card to the doctor's office, give that to them, and then they take care of the billing aspect
they'll
after that.
They'll route it properly.
Yeah, their insurance billing department will make sure they get it billed. Well, should be making sure. Now, sometimes they don't. And that card should still be valid even after the case is settled. You still have that same card that they can use. If it's the same insurance company, then you probably don't have to show it every time you go to the doctor because they already got it on file in that situation.
Okay. So, and this is something I wanted to loop back to, is you had mentioned that when you're approaching that 15-year limit for your medicals, generally the Department of Workers' Claims will reach out to you with a letter.
Right.
But if you've moved, if you've changed locations or whatever, it's your responsibility, not your attorney. It's your responsibility as the individual to update your location, your contact information with the department, correct?
Correct. It is your responsibility to do that. And, some people say, well, I thought my attorney was going to do that. I represented you 10 years ago. I don't know that you've moved unless you've told me. I don't know that you've moved from that standpoint. So I can't keep them updated in that regard because I don't have the information to update them. Now, what I do in the settlement agreements, if we do settle the case, in the settlement agreement, I've got the phone number for my client. I've got the address they're at that point in time, and also have my client's email address. But all of those can change over time.
Yeah.
And if any of those changes, you need to notify the Department of Workers' Claims. I advise my clients that in person. I advise them in the closing letter that's sent to them. Yeah. If there's any change, notify the Department of Workers' Claims so that when they do send that letter out 6 months before the 15 years is up, you will receive that and can take the appropriate action. Because if you don't receive it, that 15 years expires without you getting it. I don't think it's going to make any difference. So
Yeah, it's going to be really hard to reopen at that point.
I don't think you can.
Yeah,
Yeah.
which is going to be a tough situation, especially when you've gone through a pretty catastrophic injury. That's why you have lifetime medical benefits, applicable in your settlement. But you've also worked really hard with your attorney to make sure this settlement is proper and fair and just
Right.
and everything else. Why would you just give up on it because you've got to keep somebody updated because you decided to move?
Correct.
You really got to be on top of it.
Yeah, my recollection, I hadn't looked at it in a while because we hadn't hit that 15 years yet.
Yeah.
But my recollection is the administrative regulations implementing it puts the burden on the injured worker to notify the Department of Workers' Claims of any change in address. So if you haven't done that, since the burden is on you, I don't think you're going to have an argument that, well, the 15 years, I should be able to do it after 15 years. I think you're going to be out of luck at that point.
Yeah. Let me ask you this. You mentioned that I'll have a card, a medical card, so to speak, so that, when I'm going in to a specialist or whatever, and I say, okay, this is part of the workers' comp.
Correct.
Do I need to keep that insurance carrier up to date as well if I relocate? Am I under an obligation? I know the Department of Workers' Claims I need to, but do I have any responsibility?
If you're not getting weekly payments from them, probably not. Now, if you move and have to change doctors, then yes.
Okay.
So like if you're seeing a family doctor in Murray, and you live in Murray and you move out in the county and stay with the same doctor, probably no need to notify the insurance company of that change in that regard. Probably best to, in case they want to send something to you about something, because sometimes they offer to buy out future medical or offer something else rare, but they sometimes do that. So it's probably a good idea to let them know. But in that situation, probably not as big of a concern there. If you move from Murray to Bowling Green and get a new doctor, well, they're going to balk because they've never got any bills from this new doctor, and they're going to say, "Why is our claimant that lives in Murray seeing a doctor in Bowling Green now?" So letting them know I've moved to Bowling Green, I'm going to establish care with this doctor now that I'm in Bowling Green will save headaches on getting that doctor paid when you finally get in to see them.
I would think if I were to move out of state as well, same scenario.
Same thing, yes. If you're making a move far enough that you're switching doctors, definitely notify them. Probably a good idea to notify them on any change of address.
Okay, fantastic. Jeff, we talk about this in the majority of the episodes that we work on together here. You've got two offices.
Yes.
You've got the office here in Callaway County in Murray.
Right.
And then you've got Christian County, you've got the Hopkinsville office.
Correct.
And both of those are available to all of your clients.
Yes. I meet clients in either office from that standpoint. Haven't had a Murray client want to go to Hopkinsville for a meeting yet, but if they did, we could do that.
Yeah.
But I did a few years ago, I opened that office up in Hopkinsville to better serve my clients up in that area. It's worked out well for those clients there and worked out well for me because, before I was borrowing somebody else's law office or meeting people at a restaurant, and I never liked doing that just because we're talking confidential information, personal information in these, and I never liked doing that in the public place in that regard. So this is giving me a much better location to meet with the clients at, where it's just me and the client there and nobody else, not borrowing somebody else's office and depending upon their conference room being open or anything of that nature. So.
Well, in your clients are injured. Or have gone through some type of injury, so being able to meet, not have to drive as far. If I'm in that area of the state, I don't have to come all the way down here to Murray. I can just meet you up there, and that's worked out well, I think, for a lot of your clients.
It has. It's worked out for a lot of the clients. I've met several up there, and usually what I'll have like 3 or 4 clients I meet with in a given day up there, and so it's. I'm making the drive once for 3 or 4 clients instead of 3 or 4 clients making the drive down here for that. It saves them time, saves them pain from having to drive down here from that standpoint, and I'm still getting the value of it because I'm meeting several clients at one time.
And that lines up directly with the office motto that we've talked about on many episodes. I mean, you're looking at this from how can I make this easier and better for my client?
Yeah, I mean, my motto is to provide small town service, deliver big city results, and that I've tried to service my clients the best way I can in that regard. And if it's me driving to Hopkinsville to meet with 3 or 4, and that helps those 3 or 4, that's much better than 3 or 4 coming down here and hurting from that. I don't ever want to cause my clients to have any hurt.
Yeah, that's fantastic. Jeff, if somebody wants to get in touch with you, regardless of whether they want to see you up in the Hopkinsville office or they want to come down to Murray, you've really got one phone number, right?
I do. 270-753-0053 is the office number. Call that number during regular office hours. You're going to get a live person answer the phone 99% of the time. Sometimes we're tied up on other phone calls because they have a multi-line system. But that is the number. It just, to me, it's better in services my clients better to have one number to call than trying to call Hopkinsville and I'm at Murray, or call Murray and I'm at Hopkinsville. If we got one number, and then they can route the call to me wherever I'm at.
Kind of cuts down on the phone tag, doesn't it?
It does.
Lowers the frustration.
Yes.
Fantastic. Well, friends, I hope you got a lot out of this. We talked about lump sum payouts and lump sum benefits that might be part of your workers' compensation settlement, and then we also talked extensively about lifetime medical and kind of how that can be to your benefit, and a couple of things that you need to be mindful of so that you can actually apply for that extension if you're coming up on your 15-year mark, or if you've relocated, which is another major issue that can cause you some trouble if you're not prepared and if you're not communicating the way you probably ought to.
Correct.
Outstanding.
Yep.
Well, once again, friends, thanks for your time today. And Jeff, I always appreciate your time. We'll see you in a couple of weeks.
Thank you.
All right.
And thank you for watching.
Take care. Bye-bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.